function as the offenses. And as you correctly pointed out earlier, the statement, it doesn't have a handwritten statement from the docket by Mr. Adams. Somehow it's not available. What we have instead at 3479 is a statement, once again of the 6th of January, signed by Mr. Adams and commissioned by Mr. Perumal. This is the affidavit you referred to a short while ago regarding the case, the transfer of Major General Madondo.
Correct.
And now this is the case you suggest both General Madondo and General Kumalo were due to be arrested for in June 2026. I understood you correctly.
This would be Brooklyn 543.
That's what you had indicated earlier. We know 453 is in respect of the top secret clearances. You recall when we were looking
yes,
at...
That would be, yes, if you look at, I think that sorry, Chair, I don't mean to waste time.
No, not at all. With the Chair's permission, of course.
Because if you look at 3481 and 3482, if the numbers have remained, that's Brooklyn CAS 543 of 6/2025, and that is the CAS that then refers, yes, correct,
okay,
to Madondo and Kumalo.
Now, staying at 3479 then, we say the allegations relate to the questionable lateral transfer of Major General Madondo from KZN to CI head office by Lieutenant General Kumalo, who was assisted by other senior generals to do so, knowing that she had failed to secure a top clearance for many years. First leg of that, why is IDEC charging General Madondo for that based on what Mr. Adams alleges? What wrong did she commit by being laterally transferred? There is no suggestion that she committed fraud by misrepresenting or otherwise her clearance position or status.
It is not in this paragraph, but I do understand that that is what is being investigated in 543 of 6/2025 is fraud committed in getting, she committed fraud but in order to have herself laterally transferred.
How do you land there? This is all you have regarding her transfer.
Yes.
How do you land at a place where you say she committed fraud?
No, I'm saying it is not in here.
Where is it?
It is in the rest of the docket where they have other statements. They're not Adams statements. So I take your point again, as we did about the vetting, but just to indicate that there was in fact a fraud investigation that that was undertaken, given her own allegedly fraudulent conduct.
Okay.
It's not in this paragraph. I accept that.
I take it that by the time we apply for an arrest warrant, the charges are finalized. And I know that is the docket we had agreed we will tread carefully around.
Yes.
But on the basis that you have an arrest warrant, that suggests you have an application for a J50, which suggests you have finalized the charges. So those are more or less cast in stone. From your recollection, what is the fraud she's said to have committed without undermining whatever ongoing investigations there are? If you can.
I have the answer, but I'm unable to answer it without casting aspersions on General Madondo on a matter that is still pending review.
You are about to arrest her, Advocate Johnson,
Yes.
on the strength of a charge sheet
Yes,
that criminalizes some or other of her conduct.
yes.
I think you may disclose. You can't take that back. The only way you can take it back is for that warrant of arrest to be withdrawn and the charges dropped. So it doesn't, the nature of the fraud that underpins that charge and justifies the J50 remains. Whether you say it here or you don't say it, it's there on record. It can be changed.
I understand that, but if Chair, you will allow me, this matter is under review. I am cautious, having removed myself from the matter, that I shouldn't be saying anything that has the potential to prejudice that outcome. The review relates to representations she may have made, and it goes to an independent panel. And I'm merely saying that any utterances I make might have a negative influence. And I shouldn't do that, because that matter should be adjudicated on the strength of what is there before an independent panel. I'm not sure if the chair would allow me that, but that is the basis on which, Chair. I'm not trying to be obstinate. It is the basis on which I would prefer not to answer.
I'll support you in your request to the chair. I'll leave it there. I will not pursue it any further.
Can you please articulate what you said again, Ms.
Chair, Advocate Johnson made a heartfelt plea to the commissioners.
Yes, I heard that part. I'm not quite sure I followed what you said.
What I said was, I shall not pursue the matter further.
Oh,
Yes.
thank you.
Yeah. Well, I hear Ms. Silla is not going to pursue the matter further, but I want to ask a different question. You're related to this. Your code of conduct says something about you examining or satisfying yourself about whether evidence was lawfully obtained or material that is potentially going to be used as evidence was obtained lawfully or not. It says that. Now, we know in this affidavit, and your code says that, I think you must be familiar with
Yes.
it. If you want to check, you can look at D2, G, and then I think, rather H, in fact. And then if you want, you can look at I, but you're familiar with this. Now, in this affidavit, Mr. Adams says that this information about General Madondo, he knows it from the documents that were pushed under his door in Parliament. And you remember we had this conversation last week about crime intelligence information having clearly been obtained, not lawfully given. Did you, when you see an affidavit that says this, or when you get a briefing, because you must have been given a briefing, I expect you would have asked the question, how do we know this? Where did we get this information about the vetting of General Madondo? And you would have been told, what were you told about it? How this information was obtained?
According to the feedback, the information was obtained, Commissioner Baloy, through the Section 28 subpoena processes that followed after the 6th January engagements with Mr. Adams.
Okay.
So documents were subpoenaed,
So
and they would have been provided.
Well, in his affidavit, he tells you, or he tells Mr. Perumal, how he received this information, the very affidavit you're looking at, and he
Yes.
says, I attach here 2 documents which were pushed under my door, my office door at Parliament, and which relate to Madondo's application. Now, it doesn't call her General, so I'm reading, it's not me being disrespectful to General
Yes.
Madondo, which relate to Madondo's application for security clearance marked FA. So Mr. Perumal, or Chief Perumal, knows from this that he's now receiving and looking at information that, that was not lawfully obtained, and that Mr. Adams is not entitled to have access to and to have sight of. And so my question to you is, was that inquiry that your code of conduct says you must satisfy yourself whether that evidence was lawfully obtained, was that done in this case? Or you were all just happy to get the information and then carry on because it takes you down a particular path of inquiry?
No, Commissioner Baloy. I hadn't gone through the details of all his A1s, but I do see here where reference is marked to FA1. I have not seen FA1. In fact, when we were conferring, I was saying, am I missing something? Where's the FA1 that ought to have been here? If, in fact, FA1 was provided to Mr. Perumal, then we have to determine what that FA1 was. And if it is a classified document, then that is a problem. That should be dealt with. I haven't seen FA1 at all.
Yeah, let's assume that FA1 is exactly what Mr. Adams says it is. He says it's information or a document that relates to Madondo's application for security clearance. Let's assume that for purposes, because that's what he tells us. Let's assume it's that and it was attached. You say it's a problem, it should be dealt with. What is a problem about it? What is a problem that you say it is a problem, and when you say it should be dealt with, what does that mean?
So, if the document is in fact a classified document, there are 2 things. One, Mr. Adams should not have been in possession of the classified document. If it isn't a classified document, we all agree that that isn't a challenge. If it is is it not a challenge though, even if it's not a classified document, it's crime intelligence information. He didn't get it lawfully. It contains the personal information of a person, and he's telling your investigator, your chief investigator, that this was not given to me by General Madondo. It was under my door.
It was put under my door. So we know he didn't get it properly. Yes. So it seems to me it really doesn't matter. It may have different consequences in terms of the extremity of the consequences of it, but it remains a problem, even if it's not classified, no?
Correct.
Yes.
And so steps should be taken
Yes.
for the handling of a document.
And those steps would
unlawfully.
those steps would be against Mr. Adams
The
for
step
being in possession
of
of crime intelligence documents that are not
classified or unclassified.
that are not in the public domain.
That
Yes.
is correct.
Okay, thank you.
I want
Thank
to
you.
ask you, sorry,
Sorry.
Advocate Selo. Advocate Johnson, this affidavits, how does IDEC ensure that the affidavits are independent of IDEC's investigators? It bothers me that it is IDEC that goes to the complainant, purportedly to obtain a statement. And then the same IDEC investigator commissions that statement. How does IDEC ensure that that is in fact the witness's statement and it is not the work of the investigator? In other words, the investigator does not draft a statement for a complainant because we know the starting point is your 27 is deficient. It does not have enough information to enable IDEC to commence an investigation. Or it doesn't even bring what you are saying within IDEC's jurisdiction. Now, IDEC says this is not enough, I want something more. And the very investigator that goes back to the complainant now commissions the same affidavit. How does IDEC ensure that follow-up affidavits now contain the information that will clothe IDEC with jurisdiction it did not have when the complaint first came in? I mean, is it not more appropriate to say, your statement is not enough, go make a statement that deals with these issues, have it commissioned, and then give it to IDEC, instead of IDEC being the one that solicits the affidavit and commissions the very affidavit it has solicited?
So, if I can start one step back. Ordinarily, Commissioner Khumalo, and I know that this is within your remit and knowledge, when investigators, and it's not just IDEC, or whether it is the detectives, including DPCI, they go and take statements of the witness, and they commission the statement. The check and balance that we have sought within all of the law enforcement fields over the years is to ensure that it's not one investigator going down to take a statement. In this instance, it was the prosecutor, Advocate Ramsamy, who was supposed to have been present, together with Mr. Mansa and Mr. Peramal. So much so that it must be an engagement with the witness, and as the witness talks to the issues, they are noted. And then the statement is drafted. It has to be read back to the witness, and when the witness agrees, the statement is signed and commissioned.
That's what happened in this case.
In this case, that is why there were the three of them. And that is the practice. I'm unfortunately not
Is it to avoid the very issue that I'm raising, that it cannot be the same investigator going to a witness and saying, do a statement for me and I will commission it for you?
Correct.
Especially in circumstances where even the original Section 27 was solicited by the same investigator. It's different from a police case where a complainant would come to a police station and would lay a complaint or make a statement. Then the investigating officer would do follow-ups. Here, the original statement is solicited by the same person who commissions the follow-up statements.
I hear you, Commissioner. I can't take it further than the point I made about why there's more than one person who goes.
Yeah.
But I think in terms of perhaps advice and recommendation, it should be stipulated that it is preferable that that kind of engagement not happen and it be an independent investigator.
And I'm not suggesting that this is what happened here.
I understand.
But you can see the danger of an investigator who doesn't like a Sandile Khumalo finding a complainant and say, you know, we're going after Khumalo, so make a statement along the lines of Section 27. I will commission it for you. And on the basis of the very statement, I will then commence an investigation against, you know, the person that I don't like.
I take Commissioner's point.
Thank you, Commissioners. Yes, Commissioner.
Just to clarify names, you have more than once referred to Mr. Manta. Is
Yes,
that the
ma'am.
same person as Mr. Rapesu?
Rapesu.
It's the same person. Thank you.
Oh, thank you, Commissioner. I thought it was yet another person. I had him down as Mr. Manta. Oh, okay, clarified. Staying with 3479.
Sorry, 34?
Staying with page 3479. This is regarding General Madondo. And following on your engagement with Commissioner Baloyi, I'm at paragraph 3. We know the complaint is that she got this lateral transfer without a top secret clearance certificate. At paragraph 3 states, Madondo poses a risk to CI, the subs, and the country. I'll skip the next sentence. The last one, I don't understand how a senior officer who cannot be trusted is able to access and be in possession of intelligence reports and documents. Now, on the basis of these allegations and subsequent investigations, then IDEC has charged General Madondo in terms of CAS 453/06/25, correct?
Correct.
Why, I take it Mr. Adams is also being charged. What's good for the goose must be good for the gander. If General Madondo not having that clearance certificate poses a risk to CI, the subs and the country, I dare say so too is Mr. Adams. You agreed that he doesn't have you're not aware of him having a top secret clearance certificate, and yet he is handling documents seemingly that come from crime intelligence and for which he doesn't have lawful access or authorized access. Once again, we are in that logical terrain where I say, if we accept that General Madondo has committed a crime and poses the risk that is articulated at paragraph 3, so equally too must Mr. Adams. Logic would dictate for me, unless I'm persuaded otherwise.
No, logic dictates correctly.
Yeah, correct. So we can expect IDEC to act at least on their very whistleblower on this part, on this point.
If I speak under correction.
Absolutely.
But he is arrested, I think, amongst others, for this contravention.
By IDEC?
Not by IDEC.
No, it's
Yes.
IDEC. Remember,
Yes.
it's IDEC who sought to arrest General Madondo.
Yes.
And this is part of the same investigation. It's facts flowing
Absolutely.
from the same investigation.
The
So
law-
arresting General Madondo, equally I say,
Should
unless
be-
there's a reason why IDEC then decides not to take action against Mr. Adams. Would there be a legitimate explanation for that?
No.
Okay. Well, we will see. Lastly, when we started last week, we've been asking about the documents that Mr. Adams says, he does say so in his section 27, that were shoved under his door at Parliament. Now, he says here, specifically those which relate to Madondo's application for security clearance marked FA1. That tells me that IDEC has those documents. They are within IDEC.
And that is where we need to look at is the document that we said would come just before lunch, the other file. And I did send you that file, Advocate Maga.
Oh, we'll check that, but at least for
So
the
we must
moment,
check
we
it.
know that IDEC has them.
It should be in that file, yes?
No, you are answering the way. I'm saying for a fact, IDEC has FA1. The documents that were part of the documents shoved under Mr. Adams' door.
I cannot answer till I see the file because
No.
I didn't see FA1.
The affidavit is telling you. The affidavit itself says they are attached marked FA1.
Yes, if he's given them as FA1, then they must be there.
FA1
I'm
is
saying
not,
I did not
at
see
least
them,
FA1
yes.
is not in the file that I got. The sheaf of papers you gave me doesn't have FA1. But I argue to you that on the basis of what he says at 2, Mr. Adams, I have no reason to doubt that Mr. Adams gave the investigators those documents which he marked FA1 to this particular statement. So IDEC has them. It can be a quibble, otherwise
No.
you are forced to then say Mr. Adams is misleading in that affidavit at paragraph 2, and you've got no basis as far as I'm aware to say so.
Correct.
So I know this affidavit was commissioned by Mr. Perumal on the 6th of January 2025. You said to Commissioner Balo you haven't seen FA1. To your knowledge, is Mr. Perumal available to assist us if we're to make an immediate inquiry regarding FA1, this annexure? And would he be able to, even if on an emergency basis, just to present himself before the commission tomorrow morning to speak to these matters?
He is unable to.
Why not?
I'm not sure if counsel did speak.
If I may assist you.
Yes.
When we sought some of the documents that the evidence leaders wanted, I think the docket concerning Langlachte, we received an instruction to the effect that the person in possession of that docket is Mr. Perumal. And we sought instructions as to whether we can have a conversation with him. we were informed that he's not well. He was hospitalized during the course of the past weekend, so that we also didn't have access to him. The information I received last night was to the effect that he was discharged during the course of yesterday, and that attempts would be made to get that docket from his office, but we haven't had access to him at all. Fortunately for me, I haven't a medical certificate of any kind. So I don't know what is the actual problem with him. Hopefully during the course of lunch, one will get an idea, because part of the promise that was given to us was that that docket would probably be available around about lunchtime, because somebody was going to be dispatched to his office during the morning session today to try locate it. So we'll get some information during the course of lunch, and hopefully we'll have something to say to you after the lunch adjournment.
Thank you, Mr. Bodlani.
Thank you, Chair. Thank you, Mr. Bodlani. Then if I may, as has become standard request, that as you communicate with Mr. Perumal, I don't know how, this is one of the documents that we are looking for. We're looking for the FA1 to the affidavit that he commissioned on the 6th of January.
Commissioner, through you, I will take a chance at lunchtime, because it is important to do so, and see if we can get him on the telephone. If not, if there's a family member that does answer and is able to answer their question, is just to ask if he can just give us an indication. That much I will try. But
Thank
for
you so
the
much.
docket, I'm aware that someone would bring it to us not later than lunch.
Thank you.
Thank you, Chair. Thank you so much, Advocate Johnson. I'm indebted. The next statement we have is at 3483. And once again, you'll see at 3484, it's commissioned on the 6th of January 25. It's got that Pretoria Cape Town problem as well, and by Mr. Perumal. This is the one that I say, we've seen this statement before. It's the Mukwele A1. And I think we have dealt with it sufficiently extensively. My last statement that we've provided to the Commission is at 3485. And this one, you referred us to it earlier. This is regarding the break-in at General Lushaba's house. But this particular statement I see is commissioned by Manta Robert Rapesu in Cape Town on the 6th of January 2025, as you see from page 3486. This one, at least as to where it was commissioned, is not as schizophrenic. It says Cape Town.
Yeah, so they
Yes,
didn't move Pretoria to Cape Town for this
Yeah,
one.
for this one, yes. But it's still on the 6th of January.
Yes, correct.
Now, from CJC 394, those are the documents that the Commission added. Those are the ones we received. And there are 4 of them. If you flip through them, they're all commissioned by Mr. Mancha Rapesu on the 6th of January 2025 in Cape Town. The testimony that we will hear, and you indicated this earlier, that the 2 investigators and prosecutor, is it Advocate Ramsamy?
Correct, ma'am.
Advocate Ramsamy, Investigator Rapesu, Investigator Perumal went to Cape Town on the 6th of January. No, went to Cape Town. And on the 6th of January, obtained statements from Mr. Adams. I think 5 in total. And that all those statements were commissioned by Mr. Rapesu in the presence of the other 2 being Investigator Perumal himself and Advocate Ramsamy.
Correct.
And that what we have at CJC 394 are the actual statements taken on the day. And that the statements we have spent the last time working through, commissioned by Mr. Perumal, are a post fact. That on the 6th of January, Mr. Perumal did not commission any statement. That's the evidence that we shall hear.
Okay.
And that they were all commissioned by Mr. Rapesu. To that end, because we are armed now with two sets of statements, much like Cape Town Orlando situation dockets, but that don't speak to each other, the witnesses say they do not know the statements purported to be commissioned by Mr. Perumal.
Okay.
They attest to the documents that the commission has submitted this morning at CJC 394. It was a bit of a mental exercise to try and marry them, and both have provided short voice notes to explain why it is they challenge the validity of these documents commissioned by Mr. Perumal. And Chair, Commissioners, through you, I beg leave to play. They are very short notes.
Before you do that, does that include 3485? Because 3485 was
It is by Mr. Rapesu.
commissioned by Rapesu. So
Yes.
should it not be part of CJC 394 if what you are referring to applies to statements in CJC 393?
It would be, except that 3485 was provided by the
Oh,
witness.
okay. But you're
I
not suggesting that 3485 is also a post facto?
No.
Yeah, okay.
It's only those commissioned by Mr.
Perumal.
Perumal.
The Pretoria, Cape Town.
The Pretoria, the schizophrenic ones here, yes.
Then we are clear.
So before I play these clips, because I think they explain and the basis for why they so contend, I must place on record that both witnesses will be appearing before the commission this week. They'll testify to what they state in those voice notes, and their statements should be coming through any moment soon. So it is necessary that through them, I explain the challenges to Advocate Johnson, and then after lunch, we can then compare the two sets of statements to determine why their advice is important for our purposes.
Understood.
Very short statements. Thank you, Chair. We play the first. The first one will be a female voice, the other will be a male voice. Where you hear a female voice, that's the voice of Advocate Ramsamy. When it's a male voice, that's the voice of Investigator Rapesu. Thank you.
A1 taken by Dylan on the 6th of January 2026, and then a supplementary taken on the same day by Rapesu, 6th of January 2025. So why would two investigating officers sitting in the same boardroom have taken two different statements on the same day? And I can confirm that in my presence, there was only 4 statements taken. They were the 4 supplementary affidavits, which I have provided to you. The A1 was not taken in my presence, and it could not have been taken on the 6th of January. One, we didn't have the Cape or the Pretoria stamp with us, as is clear from the supplementary statement. 2, Dylan did not take or commission any statements in my presence. 3, we had one vehicle, we all traveled together, and all meals were done together. We even sat at the pool for a long time and chatted and whatever. So when exactly would Perumal have taken the statements on the 6th if we were together?
Thank you. That was the voice of Advocate Ramsamy. And we play the second clip. That should be Investigator Rapesu.
This A1, actually I don't know how to put it, but it could not have been possible because on that day we only obtained the supplementaries. So there was no way Dylan could have obtained that affidavit on that day. And maybe my thinking is that maybe it was signed on a different date, which I don't know. Also, remember, I was questioning that signature of Fadiel. It looks like someone was trying to jigger it, but I'm not an expert, I don't know, but it looks like. So I think that affidavit is obtained after. It was not on the 6th. So, yeah.
I think both were fairly audible. There's no need to replay, and I think the import of the respective message is duly delivered. So, as I indicated, Advocate Johnson, these are the two witnesses who support an exhibit CJC 394, which are the statements that the Commission has added to the exhibit file. And they deny any knowledge of those statements as commissioned by Mr. Perumal, and their testimony will be that whenever it is Mr. Perumal took those statements from Mr. Adams and commissioned them, it definitely is not on the 6th of January 2025 because they were together at all times. And Mr. Perumal himself was present when Mr. Rapesu commissioned the statements.
And he said the signatures were jiggered, means they were tampered with, or they're not a true reflection of Mr. Adams' signature in terms of the statements allegedly taken and commissioned by Mr. Perumal.
Yes.
Did I get that right?
Yes.
Okay.
And he does say, though, he's not a handwriting expert. At least let's give him that much.
Yeah. It's just jiggered, but he
Yes.
doesn't know more than
He says it looks jiggered to him. Right. Now, you must recall that when we were dealing with our A1 statement in the Mukwele matter, our A1 statement in that docket is the quote-unquote Perumal statement. So, Chair,
You
yes.
say, Chair, let's break. Can I just check something? Ms. Johnson, considering the dates in the Perumal, I'm going to call it the Chief Perumal statements, which is the 6th of January, and then on the same day, Rapesu also, it's the 6th of January. Would it be normal, I can't think of the correct word, but that you would have an A1 statement on the 6th of January taken by a member of this 3-member team, and on the same day you have the same team, you have a supplementary statement. It seems to me intuitively that you just have one A1 statement if they were all traveling together and they were interviewing the complainant together. Am I right, that
Correct.
you would have one comprehensive statement?
Procedurally, it does not make sense.
Yes.
What might have made sense is there were 4 statements to be taken. If perhaps Mr. Perumal took 2 and Rapesu took 2,
Yeah.
but on those same matters, and then they end up with a total of 4,
Yeah.
that is logical. But you cannot have one team together, same day, same place.
Taking a main statement and a supplementary statement.
And bearing in mind, Chair, that the purpose was for a supplementary statement to bolster